A common question I get every week is, can I get a letters of testamentary without filing a probate? And the answer is no, you can't. That is the purpose of a probate case. Either one, to admit a will into probate as being the last valid will of the person who passed away, or if they died without a will, to admit a personal representative on behalf of the deceased person. The answers are going to surprise you in this video. Hi, I'm attorney Chris Benson, and welcome to our YouTube channel, Listen to Your Lawyer. I've been an estate planning, probate, and bankruptcy lawyer for the past 31 years. We help people every week who have lost a loved one and need to file a probate case with the court. Here's how the question comes to us. You're trying to handle the assets of somebody who passed away. You've contacted a bank or maybe a stock brokerage or a real estate broker to sell a house, and somebody has told you that you need letters of testamentary. It's a weird word, but I'm going to tell you what it really means. Once a probate is opened and a court order is entered and it's signed by a judge, that court order then goes to the clerk of the court, and the clerk of the court issues these things called letters of testamentary if you died with a will, or letters of administration if you died without a will. That's what we call in our firm the golden ticket. Nobody will talk to you until you have the golden ticket, but once you have that, then everybody has to deal with you. Here's why I get the question. It's a weird word. It says letters of testamentary. You're thinking it's like a letter that you can go to a lawyer and the lawyer can draft a letter saying yes, the person passed away, or yes, the person signed a will, and that the lawyer can issue a letter that gives you the authority. And I know it's a bad phrase and a bad word, but it's been carried throughout history. But that's what it's called. It's called letters testamentary, and it's issued by the clerk of the court. Here's another common event that occurs on a regular basis. People will come into my office and they'll have the original will, and they'll be madder than hell at the bank. And they'll say, I went to the bank and I showed them the original will, and in the will it says I am the executor and I have the authority to administer the assets of the person who passed away. The bank won't honor it, and the person is upset with the bank. It's understandable. I get it. You think that having the will is good enough, and it's not. The will is just pieces of paper until somebody dies. The old phrase is a will speaks at the time of death, which means, prior to that, it's just pieces of paper. People have the ability to make multiple wills. They can change them. They can be executed at a later date. So a will means nothing until it's filed with the court and a judge has reviewed it, and you've filed all the proper court pleadings to prove that it's the last will and that it's been witnessed, and it complies with what's called the will statute. And once you've done all that, then the court will enter an order admitting the will into probate, and then that order goes to the clerk of the court, and in that process, the clerk of the court then issues the letters testamentary. So don't be mad at the bank. The bank is doing the right thing. Once you bring the letters testamentary to the bank, then the bank will honor the court order and the letters testamentary, and then you'll be able to administer the assets of the deceased person. So don't be mad at the stockbroker. Don't be mad at the financial company or the bank or the title company. They're doing the right thing. They know that the will is a starting point in the process, but it's not the legal authority. The legal authority comes from the judge and from the court clerk by issuing the letters testamentary. Why is a probate case necessary? Well, there's a lot of reasons why that might be. It might be that somebody died and owed title to real estate. They might have a bank account where there's no payable on death beneficiary. It might be a life insurance policy where they failed to designate a payable on death beneficiary. It might be a retirement account where somebody failed to designate a payable on death beneficiary. There are lots of reasons why you might need a letters of testamentary before anybody will talk to you. But that's only issued by the court, and it's only issued by the court clerk. I know it says the word letters, but it is not a letter that I can write, or it's not a letter that you can write. It's a legal document that is issued by a court. So the question becomes, well, how do I get a letter of testamentary? The only way you can do that is by filing all of the legal documents that are required to officially open a probate. You have to file a petition and an oath. You have to inventory the assets. You have to publish notice to creditors. You have to make court appearances. You have to follow the court procedure required to do that. You have to send notice to beneficiaries. That has to have the proper amount of time. There are a lot of details that go into having a court actually sign a court order granting the probate, and also having the clerk of the court issue the letters testamentary. So the next obvious question is, can you file a probate without a lawyer? And the answer is yes, you can, but should you is a different question. You can file a probate. There are a lot of court rules you have to comply with. You have to do everything exactly right. The judge has the opportunity to review all the documents, all the evidence you present. If the court doesn't like it, then the court will not open the probate, and they'll give you other instructions on things you need to do and make additional court appearances. With a lawyer, you have a higher chance of success. A probate is a difficult matter to handle because of obvious circumstances. Somebody's passed away, you're dealing with different assets, you're dealing with family members, so it's a high stress time. To add the layer of the stress of going to court and doing everything the right way complicates matter. So I've been doing it for 31 years. Not every probate case goes smoothly. Even though I know what I'm doing, we still run into bumps in the road. But it's easier for us to identify the potential problems in advance and be able to try to fix those before we make the court appearance. So, can you file a probate on your own? Yes. Should you? Probably not. Thank you for watching this episode of Listen to Your Lawyer on our YouTube channel. If you have any questions, feel free to send me a direct email. I'll be happy to answer any questions. I get them every week. My email address is on our website, along with a lot of other additional information. And remember, always listen to your lawyer.